Good morning. Good morning and welcome to the House Judiciary Committee. It is January the 14th of 2025, and we're here to get a briefing related to non-economic damages in Maryland. We're going to hear a couple different presentations. We're going to hear first from the Department of Legislative Services, and we'll hear from them, and then we're going to hear from NCSL. The Department of Legislative Services is going to talk about a report that they're going to release, that they are releasing today, that talks about some of the history of what we've done in Maryland on this issue, and other issues related to this issue specific to the state of Maryland. And then we're going to hear from NCSL, who's going to give us more of a background on what happens nationally on this issue. Before we begin, I'm going to try to properly welcome our newest delegate to the committee, Delegate Congolo, who is here. He represents the 31st Legislative District in Anne Arundel County, and we certainly welcome you to the committee, and I hope the hazing won't be too serious for you. All right, with that, we welcome you, and why don't we begin with Shamari and Holly. It's your show. You get to begin.
Thank you. Good morning, Chair Clippinger and House Judiciary Committee. Those not on the for those not on the committee, my name's Holly Vandergrift. I'm a policy analyst with the Department of Legislative Services and one of the counsels for the House Judiciary Committee. This is my colleague.
Hi, Shamari Taylor. I am committee counsel for the Senate Judicial Proceedings Committee. I came over just to help out.
It's his first time here.
Yeah. Please don't haze me.
Where do you work again usually?
Across the street.
The other team.
Today we're going to be discussing non-economic damages for personal injury and wrongful death. We will be highlighting some of the notable points from the non-economic damages report that will be distributed today. Next, you want to go to the next slide? So just a brief introduction on what we will be doing today. Shamari and I are going to start the presentation. We're going to be providing an overview of the non-economic damages cap in Maryland, the legislative history of the cap, and some legislative developments surrounding the cap. And then we're going to pass the presentation off to Ms. Heather Morton with NCSL, the National Conference of State Legislatures, who will provide the state comparisons. Today, when Shamari and I are presenting, we're going to be referring to Section 11108 of the Courts and Judicial Proceedings article. This is for personal injury and wrongful death. Our presentation, similar to the report, will not discuss non-economic damages for medical malpractice. That is governed by a separate statute. You're going to refer to Title III, Subtitle 2A of the Courts article for medical malpractice statutes. And now I'm going to hand it off to Shamari.
Okay, so first I'm going to talk to you about a little bit about what damages are. And so if we could go to the next one. So damages are any money claimed or ordered to be paid to a person as compensation for injuries or losses. And so in personal injury and wrongful death, there's three main types of damages that can be awarded. The first are compensatory damages that place the plaintiff back in the position they were, give money to them. There's two types of those. That's economic damages, and that includes damages for lost wages, as well as medical expenses, past and future expenses. And then you have non-economic damages. Those are less quantifiable. Those are more subjective, pain and suffering and the like. And then punitive damages. And so can we go to the next slide? So as I was saying, economic damages, those are tangible financial losses. These are objectively verifiable, and you can prove these through medical bills, testimony, through income, pay stubs, stuff like that. And so they include the past and those expenses reasonably expected to be incurred in the future, lost property, lost business opportunity, and property damages, including repair and replacement. Non-economic damages, those are the intangible losses. Those are more subjective, and those are more difficult to quantify. And they include pain and suffering, intentional infliction of emotional distress, loss of care, loss of support, loss of enjoyment of life. And then you have punitive damages. Those are sometimes referred to as exemplary damages, and those are awarded for punishment and to deter intentional and reckless behavior, and those are for actions motivated by malice. These aren't economic damages or non-economic damages because they are not awarded to compensate. They're awarded more for public policy reasons. Okay, so next slide. And so in Maryland, we do not have a cap on economic damages or punitive damages. However, there is a cap on non-economic damages. Next. And so non-economic damages are defined in the Courts and Judicial Proceedings Article 11-108. And so in personal injury actions, non-economic damages are pain, suffering, inconvenience, physical impairment, disfigurement, loss of consortium, or other non-pecuniary injuries, non-financial injuries. And then in wrongful death actions, the code defines non-economic damages as mental anguish, emotional pain or suffering, loss of society, companionship, comfort, protection, care, marital care, and other non-economic damages authorized under statute. Next. And so some examples of non-economic damages, the most obvious, the most common you see is pain and suffering. That's physical and mental pain, mental anguish suffered as a result of an injury. Pre-impact fright, that's anguish suffered prior to an injury. That's the apprehension a plaintiff feels prior to a fatal injury, being hit by a car. This pain suffered while drowning, that's compensable under a non-economic damages theory. Inconvenience, not necessarily pain and suffering, but just the inconvenience of an injury, that's also compensable. Inability to drive, having to use a wheelchair, stuff like that. Psychological impact of an accident, anxiety, depression, PTSD, all of these damages would have to be proved in court, or, but those are typical claims that you would see. Embarrassment, humiliation, loss of ability to participate in activities, loss of consortium, that's damages incurred to the marital relationship between spouses, and so the inability to enjoy the marriage, you all know what that means. And so ways of calculating non-economic damages, multiplier method. And so that uses economic damages to estimate a plaintiff's non-economic damages. It takes the sum of the economic damages and it multiplies it by a number, usually based on the severity or the duration of the injury. And so the more serious the injury, the higher the multiplier, the higher the non-economic damages. Typically, you see the multiplier method employed with settlement negotiations, trying to estimate what the non-economic damages should be for a certain injury, just to sometimes have a standardized way of calculating. Then the per diem method. That attempts to directly measure non-economic losses, and it multiplies the daily value of a plaintiff's non-economic loss by the number of days the injuries persisted. So for example, if there was an injury and the plaintiff sets a value at 150, whatever the injury is, and it lasts for 90 days, then you take that $150, multiply it by the days suffered of that injury. And that's an argument that you may see argued at trial by counsel, but if a plaintiff raises that argument, then the defense is entitled to an instruction that the jury doesn't have to, the jury doesn't have to, can give whatever value it decides to the injuries and doesn't have to take the plaintiff's argument. It's not evidence. Okay, next.
Okay, I'm going to take over here. Now we're going to discuss the legislative. Here? maybe. All right. So can you hear me now?
Yes.
Okay. Now we're going to discuss the legislative history of the cap in Maryland. The cap was first enacted with Chapter 639 of 1986. It imposed a $350,000 cap on non-economic damages, and it applied to all personal injury cases, including medical malpractice. It was effective July 1st, 1986. Prior to this law, there was no limit on the amount that an injured party could recover for non-economic damages. And as mentioned, it's codified under Section 11108 of the court's article. The arguments for and against a damages cap for Chapter 639. The proponents of the chapter were primarily healthcare and medical providers and insurance companies and representatives. They argued the cap was necessary to combat high insurance rates and deter the rising amounts of non-economic damages awards. They also argued that the damages were difficult to quantify, and enacting a cap was in the interest of public policy to stabilize the insurance markets. The opponents of the Chapter 639, primarily personal injury attorneys and victims, argued that the $350,000 figure was arbitrary and unfairly compensated victims without taking into account the injuries. There was also heightened debate over the constitutionality of enacting a cap and whether the cap violated a plaintiff's right to a trial by jury. So I'm going to touch on a little bit of the constitutional issues that surrounded Chapter 639. There were multiple Attorney General letters of advice in the bill file. The bill file was just over 850 pages, showing how complex and contentious the legislation was. One of the Attorney General letters, dated May 6, 1986, to Governor Harry Hughes, concluded that Chapter 639 was constitutional. The letter referred to a 1985 U.S. Supreme Court summary disposition in Fine versus Permente Medical Group, which upheld a $250,000 cap, which was imposed by California on non-economic losses in medical malpractice cases. Next one, thank you. The Attorney General's initial advice letter was on the bill as introduced, which Chapter 639, when it was introduced, only applied to medical malpractice damages. The bill was later amended to apply the non-economic damages cap to all personal injury cases, and Maryland was the first state to adopt a limit generally applicable to personal injury cases. The Attorney General's letter later concluded that even though Chapter 639 had been amended to apply to all personal injury cases, it did not change the office's opinion that the equal protection standard to review the legislation was the rational basis test, and the preservation of viable insurance programs in personal injury cases was a legitimate goal. When evaluating whether the damages cap violated Article 19 of the Maryland Declaration of Rights, the Attorney General's office determined that the chapter did not deny claimant due process and access to the courts. The next legislative initiative related to the non-economic damages cap was Chapter 629 of 1989. This prohibited juries from being informed of the cap and required a court to reduce an award to conform to the cap if the jury awarded a non-economic damages award in excess of the cap. And this is still the law today. The next legislative initiative was Chapter 477 of 1994. According to the sponsor testimony in this bill file, Chapter 477 was proposed primarily to overturn legislatively a ruling in United States versus Streetel in 1993, which the Maryland Court of Appeals held the cap on non-economic damages did not apply to wrongful death actions. Chapter 477 specified that the cap did apply to wrongful death actions where the cause of action occurred on or after October 1st of 1994. And the act redefined the non-economic damages in wrongful death actions. Chapter 477 also made additional changes to the damages cap. It established the current formula for the cap, the one that we use today. It raised the the cap for non-economic damages, the $350,000 from 1986 to $500,000 for personal injury and wrongful death actions occurring on or after October 1st, 1994. And then it also required the cap to increase each year by $15,000 on October 1st to adjust for inflation. The Act also specified that in personal injury actions, the cap applies to each victim of tortious conduct and all persons who claim injury through that victim. And in wrongful death actions, where there are two or more claimants or beneficiaries, an award for non-economic damages may not exceed 150% of the cap, regardless of the number of claimants or beneficiaries. And the Act applied prospectively only. Since 1994, there have been a variety of bills introduced to modify the non-economic damages cap. This includes raising the cap, altering the cap, repealing the cap, or differentiating the cap based on injuries. These are discussed in more depth in the report. I just wanted to put them on the slide so you could see them. These are a few of the notable ones. None of these proposals passed. And before we go to the next slide, I'm going to talk on the next slide about the current cap, but for clarity, I don't have a slide for this. This is in the report. It's a point of clarification. So in December of 2004, the Maryland legislature held a special session, and this was to address medical malpractice issues. And in 2004, result of that special session was House Bill 2, which eventually became Chapter 5 of the 2004 special session. Chapter 5 established the foundation for the medical malpractice statutes that we have today codified under Title III, Subtitle 2A of the court's article. That is when the medical malpractice was moved out of 11-108, Section 11-108 of the court's article. That's in the report, but I think that helps just to see big picture when medical malpractice moved out and when personal injury and wrongful death was by itself. All right, now we're going to talk about the current cap in Maryland. As of October 1st, 2024, the non-economic damages cap is $950,000. The cap applies to any action for damages for personal injury or wrongful death, and it was established by Chapter 477 of 1994, which we discussed earlier. Chapter 477 raised that cap to $500,000 and has the $15,000 escalator, thus the current cap today is $950,000. The cap applies in personal injury actions to each direct victim of tortious conduct and all persons who claim injury by or through that victim, which is what we discussed earlier when I discussed Chapter 477. For wrongful death actions and multiple claimants or beneficiaries, the non-economic damages cap may not exceed 150% of the standard non-economic damages cap, regardless of the number of claimants or beneficiaries. This cap is $1,425,000. The cap applies separately in wrongful death claims and survival actions. The cap for wrongful death involving two or more claimants or beneficiaries accompanied by a survival action is $2,375,000 as of October 1st, 2024. So this just breaks down the cap. So you can see for a single claimant, personal injury, wrongful death, $950,000, wrongful death, two or more claimants, $1,425,000, which is 150% of the standard cap, and the annual increase of $15,000 each year on October 1st. So as per 629 of 1989, the jury is not informed of these caps, and if the jury does award an amount over the cap, the court must reduce the amount to conform to the specified cap. Just briefly, we're going to talk about what happened during the 2024 session, and then we're going to hand the presentation off to NCSL. During the 2024 legislative session, there was legislation proposed to eliminate or raise the cap. As introduced, SB 583 and its cross-file bill, HB 83, would have repealed the cap on non-economic damages and civil actions for personal injury or wrongful death. It would have repealed the cap entirely. Senate Bill 538 was eventually amended to raise the caps, and it passed out of the Senate into the House. It did not receive a vote in the House Judiciary Committee. This is basically showing what Senate Bill 538 proposed in terms of increasing the caps. So for personal injury or wrongful death, Senate Bill 538 would have increased the cap from the $950,000 to $1,750,000, thus making the wrongful death with 2 or more claimants $2,625,000. And Senate Bill 538 also proposed increasing the escalator from $15,000 to $20,000. And I'm going to pass it back to Shamari now to talk about the arguments for and against Senate Bill 538.
So a lot of the same arguments that were made back in 1986 and 1994 are similar to the arguments made by proponents and opponents of altering the cap. And so the cap denies plaintiffs just compensation for their injuries when a fact finder has determined the value of fair compensation based on the evidence, especially in severe personal injury or wrongful death cases. The argument essentially goes, if a jury has awarded over $950,000 as the non-economic damages that the plaintiff has suffered, why are we lowering that to the statutory limit? So as cost of living rises, the current cap may not reflect the true value of non-economic damages. Increasing or eliminating the cap may deter negligent behavior that leads to large claims in the first place. The idea goes if potential tortfeasors know that they're potentially subject to very large non-economic damage verdicts, then they'll be more careful to avoid causing severe injuries. So the other arguments is that the law as it stands favors high earners who can be compensated more with economic damages which are not capped. So for example, a high earner, someone that earns $1 million would be able to be compensated more for economic damages than somebody who is a wage worker earning much less. And so having their non-economic damages capped is fundamentally unfair is the argument. And that these differentiations may also affect differently minorities who may earn lower wages or women who have lower wages. And so their economic damages would be lower and the non-economic damages would be capped. So opponents of the legislation, they argue that raising the non-economic damages cap will negatively affect employers who will see insurance rates rise due to greater liability exposure. This leads to higher insurance premiums. Smaller businesses will be most affected by the increased insurance costs due to the lower revenue margins. Increased insurance costs ultimately will be passed on to consumers in the form of higher prices for goods and services, resulting in higher insurance costs for Maryland drivers, homeowners, and businesses. Altering the cap. Yep. Okay, so the arguments from opponents are that raising non-economic damages caps will negatively impact employers who will see insurance rates rise due to greater liability exposure. Higher insurance premiums will most affect small businesses who have lower revenue margins. Increased insurance costs will ultimately be passed to consumers in the form of higher prices for goods, services, resulting in higher insurance costs for Maryland drivers, homeowners, and businesses. Altering the cap would lead to more frequent excessive verdicts and increased litigation costs, lengthy appeals, which could cause insurers to leave the marketplace, affecting the availability of insurance. And they also argue the current cap of $950,000 with the 15,000-year escalator does not need to change because it has pretty closely approximated the rate of inflation since the cap was set at $500,000 in 1994. And finally, the state needs a consistent gap on non-economic damages because it is good public policy and creates a predictable and stable insurance marketplace.
So now at this point in the presentation, we're going to hand it off to Ms. Heather Morton, and then,
Could we actually pause right now, because that was a fair amount of information?
Okay.
And I'd like to, again, the questions from the committee, if there are questions for DLS staffers, I don't want to, I'm going to try very hard to avoid back and forth on the issue itself. If you have questions about the information that they provided, the history that they provided, or what the law is right now on non-economic damages, happy to take your questions, and then we can go from there. And I'll start with Delegate Kaufman, then Williams.
First of all, thank you all. You guys are the unsung heroes of the Maryland General Maryland General Assembly. My question is simple. Because the gentleman talked about Shamari, I think, about the arguments about higher litigation costs. And my question is, do insurers have the opportunity right now in the state of Maryland, if they so choose, to settle with a plaintiff before trial?
Yes, they do.
Delegate Williams.
Thank you guys so much. As I ditto to what Delegate Kaufman said about you guys being the unsung heroes. I guess one of my questions stems around the rationale for the dollar amounts. And I think that was one of the questions I know I had last legislative session. What was we had this dollar amount that was proposed in the amended version of SB 538. But I guess I never got a clear understanding of how, what was the rationale for the 1.75 million? Where did that number come from? How was that number derived? I don't know if you know the answer to that. So yeah.
So there was some discussions among legislators, I don't want to get too into the specifics, but I know they did look at the rate of inflation, and depending on which calculator, which side was using, I think it was just mostly the results of negotiations adjusting to inflation, and then that number came out. It's not like an official number by any
Like a percentage,
means.
like when you say just the current, based off of the current inflation rate? Or is there a specific percentage?
It was based off the inflation rate, but there was also some negotiations going on between legislators about, I guess, the political side. I don't know. I'm not privy to those discussions, but that was the number that they came up with.
Okay. All right.
I can just speak
sure.
to, I went through the bill file for Chapter 639 from 1989, or 86, and I could not find a reference as to where other than California's 250,000 cap, there was no reference as to where even the 350,000 originated from. And all of that testimony, I could not figure it out. So that might be a question for the insurance side.
Okay, thank you.
And to not necessarily, I guess I'm going to kind of go back. Don't mean to be unfair in asking the questions about the bill that was just last year, in that's really a question for the senators across the street, so we're not going to try to make you divine what the senators were thinking when they passed the bill, because I don't know if anybody can do that. Having said that, going back to Ms. Vandergrift, the number that was selected back then was a number. There doesn't, as you said, it doesn't appear that there was any kind of rational basis for how that number was created. Is that correct?
From what I could perceive in the file, again, the only reference point was the Attorney General's letters that repeatedly went back to California's cap. the 250,000, but there was no explanation as to where the $350,000 cap originated from, Chair. That's correct.
All right. I see two other questions, but I want to ask a couple questions, then I'll come to Cardin and Phillips. The first one, the caps that were listed at the end a couple slides back, those are just the caps, and they are not medical cases, medical malpractice cases, right? These are the non-medical malpractice cases. Those.
Yes, medical
Yes.
malpractice is a completely separate statute now. That's in Title 3, Subtitle 2 of the courts article. This is just for personal injury and wrongful death, not medical malpractice.
Okay, we're going a little far.
Go.
All right, she missed
Keep
it.
going.
But that's okay. That's fine. Just to say that there's a separate structure for
That's okay.
for the medical cases.
Yes, and that was in 2004 when that broke off, and the damages cap for medical malpractice was pulled out into a separate statute.
All right. And then there was a discussion about the multiplier versus the per diem method in figuring out the amount of damages. Who determines that? Is it the court that determines that? Who determines which one of those should be used?
It's really based on the parties, what they agreed on, what value they want to assign to it. There's no.
So it's not so much a rule as much an argument for what you're asking for.
Right, right.
Okay. Delegate Cardin, then Phillips.
Thank you, Mr. Chairman. Thank you for the comprehensive report. Appreciate it. I have two technical questions. The first one is when you talk about the higher cap for 2 or more claimants. So if I can do an example so that maybe we can understand. So if I'm the driver of a school bus and we get into an accident and I'm clearly at fault, and there are 10 kids who are all injured, each one of them could in theory have a claim against the driver. But the maximum that they could get is only that additional cap. Is that correct? Is that what it means when you say 2 or more claimants? Do you know that? I mean, if you don't know the answer.
I believe if they die, 2 or more.
Right.
Yes, I think that's
the example that we're talking about when we say 2 or more claimants. You can only go up to that 1,450 or 1,450,000.
I believe so, Delegate, but we can double check, but
Okay.
I believe you are correct.
All right. And then my second question goes to page 20 of your report. Can you just pull that up if possible? Slide 20. Slide, it says 20 on my thing. It says, as of October 1, 2024, this cap is 1425. This is the additional cap, the 150%. And it says the cap applies separately to wrongful death claim and survival action. So it would be a 2 cap, you could get 2 different claims if, for example, a person died in the car, 2 people died in the car, and then there was a third who was a survivor, or would it be like the parents of the dead person would be the survivor? That's a technical question. I'm sure that my plaintiff's counsel out in the audience could probably answer these for me, but I'm just curious about that because we want to make sure that we're doing things fairly, and I just want to understand those 2.
I think, Delegate, we might have to look into that, and double check, because I don't want to give you false information. I think it's an excellent question, but let me confirm before we go on the record. I just want to make sure it's the right answer for you.
Absolutely. Thank you.
Delegate Phillips.
Thank you. And this is one of these areas where often it gets very technical. So I appreciate you trying to help us understand. There was rationale in Chapter 629 of 1989, and I want to understand that rationale, which prohibits juries from being informed of the non-economic damages cap. What was the rationale as you look back at the legislative record for not informing, particularly since we all know that it's publicly available? So what is the rationale?
I cannot speak to that. I would have to, Let me look into that a little bit more in terms of the testimony. I'm not sure if maybe that was more of a policy position and move versus an actual rationale in terms of the reasoning behind it. I like to look into that and see and get back to you.
If you could, may I, Mr. Chair? Yeah, if you could, because it seems to me maybe there was some thought that there was psychology behind what a jury might do, particularly since there are 3 buckets
Yes.
that damages might go into. Can you speak to the potential for punitive damages coming from a jury versus non-economic damages coming from a jury, and how that plays into an ultimate verdict?
I can speak to that a little bit. So punitive damages are not really favored in personal injury actions. They're more for intentional torts, and they require a showing of actual malice, whereas simple negligence, it's just breach of a duty of care. And so they're not really awarded in these personal injury actions, and they require a higher burden of proof of clear and convincing evidence that there was actual malice in order for them to be awarded. So not very typical in personal injury actions.
Thank you.
Delegate Boucher.
Thank you, Chairman, and thank you for being here. I'm going to follow up on what my colleague just asked about the courts withholding the cap from the jury. Has that ever been legally challenged, and is there any case law in reference to that restriction of informing the jury about the cap?
So I don't know about court cases. I can look into that. But I was actually just looking it up because there were bills. There were several bills. I'm not sure in terms of the medical malpractice or in the personal injury proposed where the bill suggested informing the jury of the caps. And so on that side, legislatively, there have been in proposals, but I'm not sure in terms of court cases. So
Well, I appreciate it. I was just
Sure.
wondering if it had ever been challenged, because it's kind of arbitrary in a way, and I wonder if there's legal basis for the review of it. If you can find something out, I'd appreciate
I
it.
will.
Thank
I'll
you.
look into to both of those questions and get back to you.
Delegate Conway.
Mr. Chairman, and thank you, panel, for coming in today to brief us. I was wondering, is there a difference of cap if the defendant is the state of Maryland?
So if the defendant is the state of Maryland, then the total damages caps are set by the state tort claims.
I understand that. I did the bill, House Bill 114 in 2000 and something. So my question again is there a difference in the 2 caps?
Yes.
I believe it's 400,000 for state tort claims.
Thank you very much.
Except for there's some claims that are 890,000, and then there's MTA is not subject to tort claims.
Okay, if you want to get back to me with the accurate information, I appreciate it. Thank you.
Okay.
Are there further questions for the people from DLS? Seeing none, we thank you very much. And now, Ms. Vandergriff, if you'd like to go and
Okay.
introduce
Is
our
Heather-
friends from NCSL.
Okay, so Ms. Morton is going to take over here, and she's going to discuss the state comparisons and where Maryland stands with regard to non-economic damages in other states. So Ms. Morton, thank you so much for joining us.
Thank you very much. Just want to make sure that you can hear me okay?
Yes, we can hear you.
All right. Thank you. Thank you so much. Good morning, and thank you, Mr. Chair and members of the committee, for the opportunity to speak before you today. For the record, my name is Heather Morton, and I cover civil liability issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of non-economic damages within the context of personal injury and wrongful death lawsuits. Next slide, please. For those of you who are not familiar with us, NCSL is the country's most trusted bipartisan organization, serving legislators and staff for 50 years. Next slide. We serve all 50 states, territories, and commonwealths. NCSL is headquartered in Denver, Colorado, where we provide comprehensive and unbiased research on state policies and legislative institutions. We also have a small office in Washington, D.C., and their work focuses on ensuring state legislatures have a strong, cohesive voice in the federal system. NCSL does not make policy recommendations, nor do we advocate certain positions to states. Instead, we promote policy innovation and facilitate communication amongst the states. We do this because we believe in the importance of the legislative institution and know when states are strong, our nation is strong. Next slide. For today's presentation, I'm going to focus my discussion on the non-economic damages available through wrongful death and other personal injury lawsuits. Before I get started, I wanted to do a little level setting so that you'll understand what terms I'm using. Personal injury lawsuits are just as the name describes. They are lawsuits from injuries suffered by a person. The injuries may range up to and include death, and personal injury claims may be based on a broad array of statutes, including motor vehicle accidents, assault and battery, murder or manslaughter, product liability, consumer fraud, libel and slander, to name just a few. And as you can probably imagine, wrongful death claims are a type of personal injury, as are medical liability and malpractice claims. Wrongful death claims are tort claims under law and can be due to negligence or an intentional act. Wrongful death claims are civil lawsuits that are separate from any criminal proceedings that are associated with the underlying injury, like, assault or murder or a motor vehicle accident for drunk driving, as an example. Wrongful death claims can also happen, like I said, in medical liability and malpractice cases. And in many states, the medical liability and malpractice statutes are separate from the general wrongful death statutes. So for the purposes of today's briefing, I'm going to use the phrase wrongful death to refer to general wrongful death cases that exclude the medical liability and malpractice cases. And when I use the phrase medical liability and malpractice, that is including any wrongful death cases that are filed against healthcare professionals to distinguish the medical liability wrongful death cases from the general wrongful death provisions. And since some of the state statutes lump the general and medical liability wrongful death provisions together, in an effort to eliminate some possible confusion, I'm making this arbitrary decision to divide them for my remarks today. And I'm also including wrongful death lawsuits that are filed against state and local governments, because there are limitations on when cases can be filed under governmental immunity provisions, and the damages that may be limited differently than in regular civil actions. And I also wanted to point out that survival actions, they refer to lawsuits that survive the death of the injured party, and it is brought by the estate of the deceased person. And what's different about these from regular wrongful death cases is that the damages are paid to the estate rather than directly to the surviving family members. Next slide, please. So when a person files a wrongful death lawsuit, the person must establish 4 things to recover damages. The defendant owed a duty to that person, the defendant violated or failed to meet that duty of care, the defendant's violation of that duty of care, it caused the harm that was suffered by the person, and then that person suffered a compensable injury. In all of the states, commonwealths, and territories, wrongful death is a compensable injury. And as Shamari and Holly explained earlier, there are economic damages and non-economic damages that are awarded to compensate for wrongful death and other personal injury claims. The economic damages, they're tangible, they're quantifiable, and are based on monetary losses, such as medical care like hospital bills, bills for rehabilitative services or custodial care, out-of-pocket expenses, and the loss of earnings or the earning capacity. Non-economic damages are used to compensate for more subjective or non-monetary losses, like pain and suffering, mental anguish, disfigurement, loss of enjoyment of life, loss of consortium, loss of society and companionship, and the destruction or impairment of the parent-child relationship. And because these non-economic damages are more subjective, different juries may make different decisions about the appropriateness and the dollar amounts for the different non-economic damages in each case. And in wrongful death cases, the economic damages plus the non-economic damages equal the compensatory damages that can be awarded in the lawsuit. In contrast, punitive damages, also called exemplary damages in some states, are not awarded to compensate for losses, so they're not considered compensatory damages. Instead, punitive damages are awarded to punish the defendant for egregious conduct and to deter the defendant and others from committing that same egregious conduct that gave rise to the lawsuit. Next slide, please. 26 jurisdictions have caps or limitations on the amount of non-economic damages and or punitive damages. And on this slide, the states with caps or limitations on non-economic damage awards are highlighted in aqua. And those states are Alaska, Colorado, Hawaii, Idaho, Indiana, Kansas, Maine, Maryland, New Hampshire, Oregon, Rhode Island, Tennessee, Wisconsin, and the Northern Mariana Islands. In comparison, at least 30 states, Guam, Puerto Rico, and the U.S. Virgin Islands have enacted caps or limitations on the amount of money that a plaintiff may receive in a medical liability and malpractice verdict through those economic, non-economic, and or those punitive damages. Illinois, which is highlighted in brown, has a non-economic damage limitation that's on their statutes, but it was ruled unconstitutional by the Illinois Supreme Court. And to give you an example, some of the examples of the limitations are on particular types of non-economic damages, such as Indiana limits the damages for the loss of love and companionship to $300,000. New Hampshire limits damages for the loss of comfort and companionship of the spouse to $500,000, and the loss in comfort and companionship of a child to $300,000. And last year in 2024, Colorado revised their limitation on non-economic damages, increasing it to $2.125 million, and that number is adjustable for inflation. The limitation is waived, however, if the wrongful act, neglect, or default that caused the person's death constitutes a felonious killing. And in contrast, Rhode Island statute actually sets a floor on non-economic damages that specifies that the person or corporation in a wrongful death case shall be liable for damages in the sum of not less than $350,000. Next slide, please. Shifting to the focus to punitive damages, 16 states, and those are Idaho, Florida, Georgia, Maine, Mississippi, Missouri, Nevada, New Jersey, North Carolina, Ohio, Oklahoma, South Carolina, Texas, Virginia, West Virginia, and Wisconsin all have caps or limitations specifically on punitive damages. Arkansas, Illinois, and Tennessee, which are again highlighted in brown, have punitive damage limitations in their statutes, but these statutes were ruled unconstitutional by their respective Supreme Courts. And some examples for the punitive damage caps include New Jersey, where their punitive damages are capped at 5 times the liability for the compensatory damages, or $350,000, whichever is greater. So the cap is $350,000 at the max. And while Colorado doesn't have a specific cap or limitation on exemplary damages, it does allow the court to review the damages that are awarded by juries. And it gives the judge the authority that they can reduce or disallow the exemplary damage award if there's the deterrent effect of the damages has been accomplished, the conduct has resulted in the award has ceased, or the purpose of such damages has otherwise been served. But on the flip side, the courts in Colorado may increase any award or exemplary damages to a sum not to exceed 3 times the amount of actual damages if the defendant has continued the behavior in some kind of willful and wanton manner against the other person during the case, or the defendant has acted in a willful and wanton manner during the case, further aggravating the damages of that plaintiff when the defendant knew or should have known that such action would produce that aggravation. Next slide, please. And now that I've covered the types and limitations on the amounts of the damages that can be awarded in wrongful death cases, let's look at who is eligible to receive those damages. Generally speaking, a personal representative files the wrongful death lawsuit on behalf of the eligible survivors. And the personal representative they could be the person that's administering the deceased's will, like their the executor in some states, or it might be a spouse or a parent, someone like that. The survivors eligible to receive the compensatory damages depends on who the decedent is in that underlying wrongful death lawsuit. So if the deceased person was married with dependents, then the spouse and the children generally come first and second in order of priority. If the deceased person is unmarried without defendants, then that person's parents or their siblings might be eligible. And if the deceased is a minor child, then the parents or possibly the siblings or the grandparents might be eligible for this to receive the benefit or the damages, excuse me. And the order of beneficiaries may depend on the probate laws in the states. So for example, in New Mexico, their statutes provide that the damages are distributed, and I'll list the different options. So if there is a surviving spouse and no child, then the damages go to the spouse. If there is a surviving spouse and a child or grandchild, then one half goes to the surviving spouse and the remaining one half goes to the children and grandchildren. The grandchildren, if other children have already died or, died ahead of the person. If there is no husband or wife, but a child or a grandchild, then the damages will go to the child and the grandchild by right of representation. If the deceased is a minor and childless and unmarried, then the damages go to the father and mother, who shall have the equal interest in that judgment. And then if there is no father, mother, husband, wife, child, or grandchild, then the damages will go to the surviving brother or sister, if there are any. And then finally, if there is no next of kin that I've already listed, then the proceeds of the judgment shall be disposed of in the manner under the probate law for regular personal property of deceased persons. Another example is that Indiana allows custodial grandparents to receive compensatory damages, while North Dakota and Oklahoma allow grandparents to serve as the personal representative and then qualify as next of kin to receive the compensatory damages. In Virginia and West Virginia, the jury or the court, depending on the case, how it goes to which one it goes to, specifies that the amount or the proportion of the damages, that they are the ones that specify who receives each, and they divide it among each of the beneficiaries. Pennsylvania, in contrast, they limit beneficiaries just to the spouse, children, or parents of the deceased, and they don't have to be citizens or residents of Pennsylvania. And the damages that are recovered are distributed to the beneficiaries in the proportion that they would take the personal estate of the decedent in the case of intestacy, which means that under their probate law, if the person died without a will, there is specific proportions that each of them would receive. And New Hampshire, Rhode Island, and Tennessee have restrictions in statute for parents who are in arrears on child support payments. And then Indiana, Kentucky, Louisiana, Ohio, and Vermont have put in place restrictions on the ability of parents who have abandoned their minor child to receive any of the compensatory damages when the child is the deceased in a wrongful death case. So in the end, determining the eligible claimants and how to distribute those compensatory damages can be very state specific, and often will look back to the probate laws, or they may call them trust and estate laws. Next slide, please. And to begin winding up my presentation, here are some suggestions for different ways that you can access NCSL resources. Next slide. And I would be remiss if I didn't make a quick shameless plug for the next NCSL Legislative Summit in Boston, in case you're interested in attending in August. Shameless plug, full disclosure. And next slide. And finally, thank you, Mr. Chair, for the opportunity to provide this overview of non-economic damages and wrongful death cases. I am happy to answer any questions and provide additional information if needed.
See, Aaron.
I've shared my contact information on this final slide.
My
All
light keeps
right,
going up.
questions for NCSL.
I have one, Mr. Chair.
Delegate Kaufman, then Conaway.
Yes, thank you. And thank you for that excellent, can you hear me?
Yes.
Thank you for that excellent presentation and the great work of NCSL. 2 of our neighboring states do not have a cap on economic and keeps going on. And so, and Pennsylvania also. And so, but when I speak to opponents of raising the cap, they paint, frankly, a very dystopian picture of what's going to happen to the insurance market if we raise the cap. So I'm wondering, in Delaware and Pennsylvania, have we seen a lot of insurers pull out and no longer offer coverage or 50 to 70% increases in premiums? Because I'm trying to figure out which part of that concern is based on data and which part of it is based on anticipatory anxiety. So thank you.
Thank you, Mr. Chair. Thank you, Delegate Kaufman. Unfortunately, I don't have access to data as to whether or not the insurers have pulled out of Delaware or Pennsylvania in those states, or whether or not the increase, if there are increase, I guess the justification for any increases in the premiums. But I'm not sure if that might be something that the the National Association of Insurance Commissioners, they're the association to the insurance commissioners like we are to you. I could check with them to see if they have any data. Unfortunately, I don't, but I can check to see if they have anything and get back to you.
I'd be grateful for that. Thank you, ma'am.
Delegate Conaway, then the Vice Chair.
Thank you, Mr. Chairman. Thank you, panel, for coming in and testify. Does Maryland have an estate tax?
Thank you, Mr. Chair, and thank you, Delegate Conaway. Unfortunately, I don't know if they have an estate tax. I actually don't cover taxation issues, so I could check and find out.
She's here from NCSL. We can ask that question of DLS, but I believe that we do have an estate tax, yes.
Yes, so my second part was, when there's a death and the damages are paid to the estate, I was wondering, does that part of the damage amount pass directly through the estate and go to the beneficiaries versus it being taxed? And I guess you don't know that, so I guess we'll get back to that. But thank you so very much.
Thank you. Sorry that I don't cover tax issues.
We'll try and get that information for you, Delegate Conaway. The Vice Chair.
Thank you, Mr. Chair, and thank you, Ms. Morton, for being here. And thank you for giving the national picture. My question relates to something you said that was helpful with respect to punitive damages. I believe it might have been Colorado where your example was, where a judge could go higher or lower based on, the fact patterns that were presented. And you mentioned willful or wanton manner. Did you find in any of the states where a judge or jury instructions could provide for an increase or decrease based on the fact patterns that were presented? So perhaps it would be in the jury instructions, or perhaps it could be in the statute.
Thank you, Mr. Chair, and thank you, Madam Vice Chair. Unfortunately, I did not do any research into the jury instructions. That's not something I have access to. I didn't find anything specifically in statute about providing for, reductions based on the fact pattern. I did find, and I didn't include it in the slide, that North Dakota they do have in statute that they allow the judge to review the reasonableness of the economic damages, which of course are the quantifiable monetary losses. So they do give the judge that ability to make sure that they are reasonable to the actual amounts that were paid for the economic damages. So there is that example that where they go in and they give some instruction. But like I said, for the Colorado one example, it's looking at the reasonableness and whether or not there's willful and wanton behavior. Most of the statutes as they're written just use the language about reasonableness and that kind of a thing, as opposed to spelling out very specific tests that they use. That's not to say that they wouldn't do that maybe in a jury instruction, because those are maybe written and drafted with the input of the attorneys representing both sides. So that might happen on a case-by-case basis.
Great. Thank you so much. I'll see you in Boston.
Thank you.
I have a question going back to the slides that you had with the maps. You had a slide that showed the states, this one with regard to punitives and effectively the blue states have a limit and the gray states don't have a limit specified in statute. Can you, the map before this, I think, indicated which states had a cap on economic damages versus states that, the ones that do and ones that don't. Do you know how many states both don't have a cap on non-economic damages and don't have a cap on punitives?
Thank you, Mr. Chair. Off the top of my head, I didn't count them, but I can do that for you.
I'm sure we've got a copy, so I can do it too. I just didn't know if you knew off the top of your head how many kind of fall into that category, but it appears to be a relatively small number.
Thank you, Mr. Chair. I would say it's ballparking it, since I didn't specifically count it. I think there were 26 states that have some kind of cap. So then it would be, what is that? Can't do the math in my head, but
24.
about 24. There's 56 jurisdictions total when you include the commonwealths and territories. So what is that about? Somewhere around
30.
30. Thank you. That then, and then the other three. So it might actually be probably about like 25, because when you exclude Illinois and the two that have Arkansas and Tennessee that have had, although no, you wouldn't exclude them because they've been overturned. So yeah, so about
Perhaps
30
you'll
states.
get back to me with it. That's
Yes,
fine. We're not going to make you suffer any longer,
Yeah.
I don't think. But I
will
would
admit
be, I would.
that I went to law school, not math school.
I understand. I understand the lawyers in the room are all nodding their heads. Delegate Cardin.
For the presentation, just following up on the chairman's question, on this map specifically, it says it does not include medical malpractice actions. You had said something in your report about there was like 30-some states that had, was it for medical malpractice they had caps, or they had limitations, or was it for something else?
Thank you, Mr. Chair. Thank you, Delegate Cardin. Yes, there's at least 30 states. I think it's around 33 states, and then the Puerto Rico, Guam, and the U.S. Virgin Islands, where they have caps on one or more of the damages specific to medical liability and medical malpractice cases.
And so there could be some overlap between non-economic damages on this map and those malpractice limitations.
Yeah.
There's,
Yes.
okay. And then so the report that we got from DLS mentioned that our 1986 limitation was juxtaposed against the Attorney General, I think, looked at California's caps, and in none of your maps does California have any caps. Does California get rid of its caps, or is it just on medical malpractice and we don't have that map?
Thank you, Mr. Chair. Thank you, Delegate Cardin. Yes, so the California they have the medical liability caps, so that's why I didn't include them in the
Okay.
general
Thank you.
general wrongful death caps.
Seeing no other questions, we want to thank all of you very much for your work and for your presentation here today. If there are no further questions, we are finished for today. This has been the House Judiciary Committee. We're going to meet again tomorrow. We will have only a briefing at 11 o'clock tomorrow. We will not have the second briefing with the Secretary of the Department of Public Safety. That's going to be rescheduled to next week so that we can use the brand new fancy joint hearing room. All right, with that, thank you all very much. We're adjourned.